start in a minute or two. I'm Margaret Berger of Brooklyn Law School. I've been given the privilege of being the moderator for this program, and I am going to do nothing more than to tell you who is speaking and their academic affiliation, because clearly this is a conference where we need every minute to be able to ask the questions that people obviously want to ask. So, our first speaker will be Tony Seebach of this very institution, who's going to be talking about the fall and rise of blame in American tort law. Then we will hear from Valerie Hans of the University of Delaware, Whiplash, Who's to Blame? Finally, as a final speaker, we will be hearing from Jen Robinall of the University of Missouri Columbia School of Law, who's presenting on behalf of the work done by two others as well, on incommensurability and symbolism in civil sanctioning. And we will then have comments and discussions by Professor Sharon Lamb of St. Michael's College. And with that, Tony, I think we're ready to begin.
Thank you. First of all, I want to congratulate Larry Solomon and Brooklyn Law School, not including myself so much, but really Larry, who, Larry has done a tremendous job putting this sort of conference together. The work, but also the creativity and mental inspiration that brought these people together. It's really a testament to Larry's fantastic imagination, and I really think it's great. I'm going to, this is by way of excusing my very different approach to the topic of this conference. I am going to be approaching it from the perspective not only of torts, but also from that really of intellectual history. I am going to, as a methodological matter, talk today using sources that are really elite sources. And from a methodological perspective, one might say that most of what I'm going to talk about today is useless, because it really comes from a handful of people who wrote in journals and papers, and not necessarily representing what was happening in the real world of tort. However, to the extent that we think we can learn something about our world from what its leading thinkers or what the leading thinkers of the time said, I would like to present this story to you. It's a story, again, it's a story which I'm going to describe in order to gain insight on the ironies about how a community of scholars and activists can think about the same goal. Let me explain. It is really, I think, a truism that between 1960 and 1980, there was, as Gary Schwartz put it, a parade of victories for those who thought that tort liability should be expanded to help those who were injured. It was a pro-plaintiff moment in American history. And some people think that's good, and some people think it was bad. But the historical fact is really unindubitable. So there were many causes of this. Some people attribute it to changes in the social attitudes and political attitudes of the United States, the rise of the civil rights era, changes in attitudes about authority. Some people attribute it to an acceptance of a technocratic control model to social injury. And others, like Gary Schwartz, argue that, in fact, it was inevitable. It was the perfection of the fault principle, that is, expanding the opportunity to all, in a democratic way, to take advantage of the principles of fault, which were first articulated by Holmes in the beginning of the century. For those of you who don't know much about tort law, let me just list to you the greatest hits, as Schwartz put it in 1992. The end of a variety of immunities, family and charitable, for example. The introduction of auto guest statutes, which got rid of the auto guest immunities. the introduction of a liberal theory of joint and several liability to allow plaintiffs to collect from a wide range of sources, the end of special rules of liability for landowners, forcing landowners to defend themselves on the same ground as anyone else in a negligence action, the end of the locality rule, forcing doctors to be held to a generally higher national standard of care, the rise of informed consent, allowing patients to sue physicians for failure to inform them not only for botched operations, but the failure to inform them of the costs of well-performed operations. The introduction and rise of the negligent infliction of emotional distress as a separate cause of action under the bystander rule. The fall of contributory negligence and the rise of comparative fault. And of course, our favorite, products liability. Everyone knows what happened in the 60s. One important foundation for this explosion, so to speak, of the plaintiff's right in the post-60 era is, in my opinion, an intellectual movement, that is the realist critique of tort law from the 1920s and 1940s. Realists were, as you might well imagine, allied with political progressives. And on an intellectual matter, politically they, of course, believed that the law should be used to promote the interests of the betterment of society, by which they often thought the redistribution of income towards those who are less well off and to combat capital. But as a matter of tort law, they also saw the attack on these doctrines which fell in the 60s, which was really something that they wrote about in the 20s, 30s, and 40s, as a tactical way to promote a specific agenda, and that was the agenda of enterprise liability. From the perspective of the typical progressive tort scholar, the reason why you'd want to attack a doctrine like contributory negligence, or the reason why you'd want to expand the grounds in which landowners could be held liable, was in order to expand the set of individuals who would bear the costs of accidents in an industrial society. This was the principle of enterprise liability. Now, enterprise liability has a very simple premise, and that premise is, as Fleming James put it in 1940, it is better to have 100 bear the cost of an accident than the one. The idea is that from an economic point of view, for the purpose of maximizing welfare, it is always better to spread the cost of an accident over many who can pay for it either through the price of a product or by purchasing insurance, than to allow the one unlucky and unhappy consumer or worker pay for it through pain, suffering, loss of income, etc. This is why the realists supported, for example, early on, workmen's compensation. This is why the realists supported early on, as early as 1926, the famous Columbia study on auto insurance, no-fault auto insurance. Sometimes the realists even supported doctrinal positions which seemed counterintuitive at first, in the name of enterprise liability. For example, Fleming James, who I'll be referring to a fair bit today, although only because he was such an influential figure in the realist tort agenda, although I can certainly demonstrate how many others like Leon Green and William Prosser simply followed Fleming James. James, for example, took on another realist, Charles Gregory. Charles Gregory thought he was doing plaintiffs a favor by recommending the expansion of contribution between defendants, on the theory that the more defendants there were to sue, the better for the defendant. James said, oh no, you're being insufficiently realistic. Actually, if we don't allow contribution, we insist on several liability, then what we'll see is that plaintiffs will go after the wealthiest defendant first, and thereby the defendant who's best able to spread costs will pay most of those costs. If we allow contribution, plaintiffs might, in a silly fashion, go after many defendants, and then less able defendants will be forced to bear the cost of the accident and will be less able to spread the cost. Better to keep the doctrine of several liability, which at first glance seems anti-plaintiff, for the purposes of promoting enterprise liability, which after all be better for society in the end. So enterprise liability was a dominant and in some sense a irresistible intellectual tool in the hands of the progressive realists. But I want to today point out that there was a deeper philosophical root to the theory of enterprise liability. On the surface, it seemed to be, and it certainly was, consistent with a political agenda. But it also had a intellectual ground, which the realists were not shy to talk about because the realists were not, in fact, vulgar Marxists. They believed that there was, in fact, a consistency between their philosophical project and their political outcomes. The philosophical ground of enterprise liability was very simple. The realists were anti-conceptualists all the way down. They were anti-conceptualists about the concept of duty. They were anti-conceptualists about the concept of proximate cause. And they were anti-conceptualists about the concept of fault. To put it bluntly, they didn't believe there was such a thing as fault. They didn't think there was any point in punishing people because they didn't think that people made self-conscious choices to be careless. They didn't think there was any point in deterring people because they didn't think that people made self-conscious choices about being careless. They didn't think there was any point at all to using the concept of fault in the torts process because they thought the concept of fault was another example of 19th century conceptualism. I'm going to today discuss two different ways of expressing this thought. They're both, I think, very interesting and I think worth thinking about in today's context. James, over his 20-year career, spent a great deal of time looking at studies done by industrial psychologists and the U.S. Army. He concluded, as he said famously in a 1950 Harvard Law Review article, sorry, it was an accident, in a famous 1950 Law Review article, that this main explanatory device to understand negligence in a modern society was something he called accident proneness. He suggested, for example, that it would be easy to see, based on studies that he had read, that 10% of the workforce was responsible for 75% of workplace accidents, and that 4% of drivers were responsible for 33% of all auto accidents. He quoted a Journal of the American Medical Association article, which said that accident proneness may be a phenomenon independent of any question of responsibility, conscious action, or blameworthiness. Now, what to do with this discovery that, in fact, accidents are the result of a medical condition? Well, first, James considered segregating people out of society. But he noted, and this is a lovely quote, he knows that, this is a quote, "The accident prone, about 4% of the total population, can scarcely be kept out of work and off the roads." So, from an enterprise liability point of view, he concluded two things. One, where possible, the accident prone should be taken away from situations where they might cause accidents, because they really can't be made less accident prone. It's not their fault. And second, where they cannot be taken away from situations where they might cause accidents, the cost of their accidents should be spread broadly throughout society through social insurance. This, he said, counseled obviously the solution that tort law, wherever possible, should place liability on large bureaucratic organizations because the individual is incapable of acknowledging and responding to their own accident proneness for a variety of reasons, partly data collection, and large organizations like the Army, the workplace, insurance companies are much better at doing this than anybody else. So this is why he believed, for example, in all these doctrinal changes which shifted the cost of accidents to defendants. On the other side of the spectrum, there was Albert Ehrenzweig. Now, Albert Ehrenzweig had a different, he was also a quite accomplished doctrinal scholar, realist critic of the conservative model of torts, a great advocate of plaintiffs' rights. Ehrenzweig had a slightly different view. Ehrenzweig believed that Freud had taught us that, in fact, the concept of fault was merely another primitive, much like taboo, and that, in fact, objective fault, as identified by Holmes, was based on a primitive urge to blame. He argued that, of course, if one thought about it, there's no point in holding someone morally responsible for their failure to live up to a standard of care that they are incapable of meeting. And therefore, the only reason why we continue to call it fault is because of a primitive desire to attribute blame, which is something which we retained from our early primitive pre-modern era. So he basically wrote an article called A Psychoanalysis of Negligence, in which he argued that the hangover, so to speak, from our early pre-modern years is this language and rhetoric of fault. In fact, he went as far as to suggest that this would, in fact, extend to strict liability. To hold one party liable in strict liability, when we acknowledge that they are not, in fact, even at fault under the objective standard of fault, is, as he put it, to simply animate causation as a moral agent. And this, in his mind, was a primitive. Again, what this counseled him is that a modern, mature society that is becoming adult and moving into a period of adulthood as a society, would move towards social insurance, abandoning this primitive and childish taboo. Now, I want to move on now to how these thoughts about fault, which of course it's an utter rejection of fault as a useful concept in explaining tort liability and in counseling too, a move towards a non-tort, no fault, no blame model of civil liability, how this played out after the realists declined from influence. In 1959, Fleming James gave a lecture in which he looked back on tort law in the midstream, as he called it. And it was a rueful lecture. He was near the end of his career, although he was a very successful academic, as he pointed out. Only half of the things that he said had been listened to. Whenever he counseled doctrinal changes to support plaintiffs, that seemed to do pretty well. People like that. And as we would see, starting in 1960, merely months later, the explosion would begin. But the intellectual agenda, this attack on fault, was something which had been totally ignored. And he noted, from the perspective of 1959, that the state of tort law in America was not good. He said, he sort of made a few observations. First, most victims of accidents are undercompensated for their economic losses. He observed that in 1959, there was a tremendous randomness in the amount of compensation that victims of similar accidents receive. He also noticed that in 1959, most people had no first-party insurance, and the people who needed first-party insurance the most, the working poor, had it the least. He also observed that in 1959, most tort damages were not paid by the party found in fault, and he also observed that since most accidents were caused by accident-prone persons who were ignorant that they were accident-prone, putting the pressure of tort liability on them would do very little to reduce the rate of accidents. Basically, what he was describing in 1959 is the world we live in today. Very little has changed. James concluded this moment, "The present system is a miserable failure, marked by stark overall inadequacy, punctuated by occasionally fantastically high awards." This was 59. Now, what's interesting to me is, in some sense, what has and has not changed. What changed was starting in 60, according to everybody, is an effort to try and broaden the base of liability through the changes in doctrine I described. But not a single effort to try and grapple with the intellectual foundations for the expansion of enterprise liability. And in fact, I'd like to argue, in fact, exactly the opposite has happened. And this will be the briefer part of my talk, because in some sense what I'm going to tell you about are little glimpses of a world that I think should be very familiar to you. This might put it, however, in perspective in a very piquant fashion. People may be familiar with the fact that no-fault auto insurance actually got its chance in American society, and it blew it. There was a high point of the adoption of no-fault auto insurance by state legislatures starting in the 70s, and ever since then it's being pushed back. What's interesting is to observe the political language, to observe the political debate over no-fault auto insurance. We could have an entire conference as to whether or not no-fault auto insurance failed or not. There are such people like Jeffrey O'Connell who believe it was sabotaged from within. It's interesting, however, to note that at the beginning, consumer groups, like Consumers Union, were the strongest advocates for no-fault auto insurance. You can go back and look at Consumer Reports 72, 73. They suggested that this was obviously the best thing for consumers. What's interesting is what changed in the intervening period. Starting in 1990, Consumers Union opposed no-fault auto insurance. And much because under the pressure of Public Citizen, and Public Citizen's one-time leader and now guardian angel, Ralph Nader. And here is Ralph Nader in 1999 on why no-fault auto insurance should be rejected by the federal Congress. There was an attempt to try and federalize no-fault auto insurance. This is Nader in 99. "No-fault systems explicitly contradict the fundamental principle of American justice, that wrongdoers are held responsible for the harm they cause. By eliminating fault, no fault effectively treats good drivers and bad drivers the same. This is not merely a philosophical concern. A body of evidence shows that no fault leads to more accidents because it weakens the deterrent effect of the tort law. Now, of course, what's fascinating is that Nader is the love child of Fleming James. Okay, I mean, there is a way in which the consumer movement grew out of the realism of the 20s and 30s. And yet what's fascinating to me is to see how the language of fault has become completely flipped. I picked up two recent books, both published in the last 12 months, both published by self-identified pro-plaintiff, pro-consumer advocates, both excellent books. But what I want to point out is how they characterize the fundamental purpose of tort law. For example, Thomas Koenig and Michael Rustad argue at the end of their book. This book is a fascinating way in which it covers tort law, despite the fact that the vast majority of tort litigation does not involve punitive damages. The vast majority of examples they give involve punitive damages. Well, there's a point to that, because they believe, as I will say here, as I will point out in their conclusion, that the most important latent function of tort law is the business of interstitial legislation. What do they mean by this? That is, of compensating for wrongs that are rarely punished through criminal law. Meaning, this is a gap filler for the law that is supposed to incentivize people to act right. Similarly, if you look at Carl Bogus' recent book, Why Lawsuits Are Good for America, he suggests that the reason why suits such as tobacco lawsuits or the handgun lawsuits, all these very large, vast lawsuits which some people believe are inconsistent with the fundamental principles of tort law, is that in fact, and this chapter is fascinating, he says all we're doing here, because he is in fact an active litigant in these cases, is using the principle of personal responsibility to instantiate justice through the tort system. And this chapter says, well, really all I and my colleagues in the tobacco and handgun litigation are doing is doing exactly what the liberal virtue of personal responsibility counsels, which is to hold people responsible for the choices they make. Now, to conclude, let me explain why I think this is interesting. It's interesting from three levels. It's interesting from a historical point of view. I mean, I just find it fascinating that the history of progressive tort law should have undergone such a tremendous conceptual flip without actually, in some ways, undergoing a doctrinal flip. Although there are places where the doctrinal flip breaks down. For example, no-fault auto insurance. Also, damages. If you go back and look at Fleming James, the part I didn't read to you about his lecture in 1959, is Fleming James makes a very interesting observation. He said, well, social insurance through enterprise liability is obviously the most just thing for a modern society. However, you got to understand something. You're going to have to give up non-economic damages. That is, the point will have to be to focus on economic damages, loss of wages, medical expenses. But he notes, he says, I'm really worried from perspective 59 about the increase in pain and suffering awards. Say nothing about punitive damages. Right? Now, what's happened in the last 40 years is clearly there's been a change both in the actual volume, quantum, and I would say qualitative focus of tort litigation towards both non-economic and punitive damages. We can debate about whether or not this is epiphenomenal or not. But from where I stand in the academy, it is fascinating to me to see leading scholars point out that the tail, so to speak, should be wagging the dog. Why do we want to have a tort system, says Rustad and Koenig? It's so we have a vehicle by which we can punish wrongdoers. Now, of course, to the realists, they would have said, this is crazy. This game is not worth the candle. If you want to have a system in which you spend most of your money pursuing those 2% of wrongdoers and leaving the poor without any compensation for their fender benders, you are not acting in a just fashion. But of course, Nader has a very easy response to this, and his response is twofold. One is, if we don't go after the wrongdoers when they act wrongly, they will consume all of us. They will grow out of control. And secondly, Nader's response, and this is another place he's written, says, there's something more important here than efficiency. There's justice. And the true agenda for a progressive tort scholar is to spend the extra money on the margin to find the wrongdoer, even if it means we don't compensate the poor for their no-fault fender benders. And of course, this shows a great divide in what it means to be a progressive in tort law. Are we interested in maximizing the welfare of those who participate in a complex industrial society, or are we interested in what I would call torts expressivism, in using a tort system to pursue those episodes of grievous wrongdoing so that we can, in some sense, characterize ourselves as a nation, as a people, and use the tort law as a gap filler for what is not being done perhaps by other public institutions. So I don't see this as a contradiction worth criticizing, but I do see it as a development worth commenting upon. And with that, I'll leave it.
Very interesting talk. Thank you for starting our panel out so well. I want to thank Larry Solin and Dean Wexler, as all the rest of us have had good cause to thank them. In part, it's so exciting to be at a conference where people are working on somewhat different approaches to the types of issues that motivate us, and it's very stimulating and very enriching. And I found the discussion of prototypes and exemplars, in fact, in the last panel, to be quite interesting. And to that effect, and to promote integration among the panels, I offer you the prototype of a whiplash victim. This comes from some web surfing that I did using the term whiplash and jury. And it comes from a song called Talk to My Lawyer by a songwriter called Chuck Brodsky. And these lyrics are available on the web for your edification. The song Talk to My Lawyer, the protagonist gets himself in a number of accidents. And the one I want to focus on here is a car accident. He describes an accident that he had that he, by himself, as the victim says, is not too bad, just a little dent. But luckily, it was a Mercedes. And the person driving the car gets out in a three-piece suit, offers him $1,000, and he said, no, let me think for a minute here. And the words of the song, I'm going to talk to my lawyer. I might have whiplash. I might have trauma. Let's not talk petty cash. I've got a witness to put a hand on the Bible. Jury, hallelujah, you might be liable. Now, our protagonist is very optimistic about the prospect of a jury looking at his whiplash case. But I am less sanguine, having had a chance over the last several years to look at what people think about injury victims. And I want to make the argument that, in fact, he's going to have an uphill battle, as many people who are injury victims find when they come into the justice system. Now, this is somewhat different from the popular view of the civil jury that features an image of the jury as Robin Hood, really, and I've got a picture for you just to reinforce the analogy. These jurors are bleeding hearts, very highly sympathetic to injured victims, quite hostile to businesses and insurance companies, certainly, and extraordinarily generous. Jury, hallelujah. However, the empirical evidence about the civil jury that I've conducted and other people like Neil Feigenson here has summarized in his book Legal Blame really disputes the popular view and shows that civil jurors are, not that they're never sympathetic, but they're often quite critical, very highly critical of plaintiffs, and often blame them for their own injuries, sometimes even when they are blameless or close to blameless. This is linked to, and I think part and parcel of, a broadly held and widespread view that many tort lawsuits are worthless and meritless and frivolous. Now, how have we come to this situation? I think there are a whole series of possibilities, some of which are rooted in psychological theory, others, I think, which are rooted in political efforts in tort litigation and surrounding tort litigation. I guess I'll talk about briefly the psychological phenomena that I think are most relevant today. some of the classic psychological theories that attempted to account for why people sometimes blame suffering victims are the belief in a just world or defensive attribution theories, now some 20, 30 years old, but still I think with some relevance today to the situation of victims, particularly whiplash victims, well, maybe whiplash victims. Belief in a just world essentially would posit that all of us have a need to see our world as a safe one in which we're not subject to sudden injuries and other unfortunate events. And when we see somebody suffering, we have a motive to figure out how to distinguish ourselves from that victim. And there could be lots of ways that you do this. One is to derogate the victim, blame the victim, point to actions of the victim, minimize the victim's injuries or the overall injuries. Of course, juries have another way to deal with this discomfort, which is to give a generous award to the injury victims. I think another thing that is going on that's really distinctive from whatever emotional reactions people have to victims' suffering is the idea of individual and personal responsibility, which you mentioned in your talk, and I think which really resonates with people. And very often, again, you might think in tort cases, the individual responsibility that you're concerned about and looking at is that of the defendant, and that juries would be assessing and focusing on ways in which the defendant might be resisting being held accountable for the injury he or she caused. But the very notion of bringing a lawsuit may be seen, and I believe in talking to jurors, is seen often as not taking responsibility for your own actions, for your own lives, and what happened to you, about trying to push responsibility onto another person or a corporate, governmental, or other entity. I think as well, there are some culprits in the media that, as Rob McCune and his colleagues have shown, tend to highlight really big, generous awards, those fantastic awards that Anthony Seebach was talking about back in the 1950s, apparently, as well as today, and highlight cases in which plaintiffs do succeed, giving people a mistaken idea about a plaintiff's chances in the legal system. And as well, there are certainly advertising campaigns, particularly by insurance companies and business interests, that promote the idea of the frivolous lawsuit, that make highly accessible and readily available to us exemplars of the frivolous lawsuit. I think the McDonald's coffee lady being the one that pops to mind, certainly among my students, if not you. I'm now doing some research on whiplash that was stimulated by a request from people at the Roscoe Pound Foundation. They asked me to develop a research program on whiplash cases and other soft tissue, connective tissue injury cases. And I've done that, and I'm in the middle of it and wanted to talk with you about it because I think it does involve some very interesting questions of why we are so interested in blaming victims, injury victims, including whiplash victims, and what, if anything, we can do about it. And the goals of the research project are, first of all, to discover in a more systematic way, beyond the prototype from Chuck Brodsky, what people think about these kinds of injuries and the person who brings a lawsuit surrounding those injuries, to take a look at what kinds of things seem to be associated with the most vitriolic anti-plaintiff views, and then to, in a very problem-focused, non-theoretical way, to be honest, to see how you could present a connective tissue injury lawsuit in a way that is more supportive and favorable from the perspective of the plaintiff. And so I thought this was a really interesting challenge that was related to some of my prior work, where I found in cases in which people sued businesses and corporations, often jurors I interviewed looked to the plaintiff's blame as opposed and seemed much more engaged and enraged about the plaintiffs than they were about the defendant's possible misconduct. So what we've done, and I've worked on it with a number of people, including Juliet D., who's in the communication department in my University of Delaware, is first of all to start with some focus groups to get at least to explore what some of the different themes were in people's views about soft tissue, connective tissue, whiplash cases, to undertake a national survey, which is done, and then ultimately, and this is what's in the future, to develop a mock jury type study where we present a standard or control case and then attempt to modify it in ways to promote the view that the plaintiff actually does have a reasonable whiplash injury. Just to briefly give you a little background on what we found so far, in the focus groups were conducted in a couple of states, Colorado and Kentucky, and there were about 40 people all told in 4 different groups who sat around and talked in a directed way about connective tissue injuries, whatever that was, car accidents, insurance, lawsuits, and so on. The national survey was 600 people who were asked attitudinal questions about the same kinds of issues and views about these types of injuries. It also included a scenario experiment that I won't really talk about, but basically we set up a very brief case appropriate for a telephone survey and described a car accident where somebody broke a bone or had a connective tissue injury, and found that the broken bone was seen as a real injury, was more likely to be granted credence, granted credibility, plaintiff was more likely to be credible, and there was more likely to be compensation. The major results, whoa. I'll get these all out. I'll get these all out and then carry on. I don't know. I think I was going wild when I was doing that PowerPoint presentation. It's the car accident theme, right? I guess I would summarize all of it is saying that, like the prototype, like the exemplar, whiplash cases are kind of the fraudulent civil litigation case. Furthermore, people don't really know what soft tissue injuries are, connective tissue injuries are. Those are really kind of mysterious terms that lawyers have cooked up to avoid using the term whiplash. And the idea of whiplash injuries were derogated and minimized, except, and this is a theme throughout the research, we've now replicated this in several different ways, if you happen to have suffered it yourself or know a close friend or family member who has had whiplash. That's one of the main things that, so, hey, plaintiffs' lawyers, get those whiplash victims. Just as an example of a couple of quotes from the focus group that I think convey the sentiment, and you'll see they're very consistent with the prototype I began with. Nowadays, if you have an accident, everyone is hurt, whether they are injured or not. They fake injury just for the lawsuit. It happens all the time, pretty common. And a Colorado man, I tend to think they're wearing a neck brace, and as soon as the check comes in, they take it off. All right, so one really clear thing that is going on here is there's this widespread connotation of fraud that would make our protagonist here really face something of a hostile jury. We asked them to rate the seriousness of a number of different types of injuries, and I think it's intriguing. Right at the bottom is sprain and soft tissue injury, which I believe is a favorite of the defense bar. Soft, not too serious, and so on. Muscle injury, connective tissue injury, which I believe plaintiffs' attorneys thought would be great because it has that kind of medical tone to it, connective tissue injury. So it's kind of a medicalized sounding tone, and therefore might seem really a little bit more serious. Well, that came at 5.9 on a 6-point scale, behind whiplash. You can see that the plain old and very prosaic neck injury is rated actually higher than some of these other kinds of injuries. Now, again, these are abstract ideas about injury, and they may change if you look at a particular injury in the context of a specific case. But if you're trying to think about what do people bring to the table, what does a juror bring to the jury box when he or she is sitting there thinking, I hear that the plaintiff has a connective tissue injury, the rating of seriousness is rather low. The fraud thing is alive and well. This is some data from our national survey that was a little bit of a surprise to me. I guess I've seen some of the public opinion surveys about how the low esteem people have for insurance companies. And it may be low, but the whiplash victim is even lower. We asked what happens more often: insurance companies deny a valid claim or a person makes a fraudulent claim. And we found, lo and behold, as these bars go up, it's a lot more likely that a person will bring a fraudulent claim than that an insurance company will deny a valid claim. Okay, that's something of the background. Now let me talk to you about this mock jury study that I'm planning. And I'm, partway through. I've been doing some pre-testing, and I thought, although I don't know that this will survive in the published paper, I thought it would be fun to talk to all of you and get your input about this mock jury study. We've developed a typical whiplash trial, and it's modeled on a case from Delaware that involved a whiplash and a car accident. So we basically took the transcript of that case and modified it to suit our purposes. And then in the experimental condition, we are attempting to insert different kinds of information, different ways to frame injuries, different approaches that attorneys could, the plaintiff's attorney might choose to modify in terms of opening statements, different ways a plaintiff himself might talk about the evidence. Our case is this is sort of a standard case, and one that actually gives rise to, I think, some problems for plaintiff's attorneys. Typical rear-end accident of case of the defendant in the rear car is distracted. She's a mom with a couple of kids in the back seat, and she's distracted by children in her car. I drew on personal experience to form this. And she winds up hitting the plaintiff's car at a red light. And so the liability for the accident is clear. I should say, even though it was clear, the first time I ran this by my undergraduate students for pretesting, about a third of them said, no, she's not liable for this accident. So anyway, that's part of this phenomenon. Now, our plaintiff then experiences chronic problems from his whiplash, which he goes to a hospital shortly after the accident. He sees his osteopathic doctor and winds up actually having chronic whiplash. And my reasoning for including this kind of thing is this is the sort of thing that might lead to a case, right? As opposed to a whiplash injury that would be over, within a few weeks. The ones that might actually find their way to court involve more chronic problems. And so our plaintiff had some pretty serious job and lifestyle problems, like in a lot of cases, and in our baseline case, the one that we took this from, the Delaware case, a fellow worker talked about the impact, the neighbor talked, the doctors talk about the injury. So these are all typical kinds of things that plaintiffs would do to shore up their own presentation. Now, the defendant admits the liability for the accident, but the defense case is that there is a dispute over whether the injury even exists and how serious it is, mentions, which is often the case again, so it's pretty realistic, a pre-existing condition of some sort or another, and then brings on some experts to question the seriousness of the injury and even the existence of the injury. All right. Now, what we did, and I hope you can see this, it's abbreviated so I could get it all on one slide and you could look at them right at one against the other. In the control case, we use the term whiplash because we want to see what happens when people look at a case where whiplash is used by a plaintiff's attorney as well as the defendant's attorney. We don't really address directly some of the concerns about fraud and motivation on the part of the plaintiff. We don't really say why the plaintiff brought the lawsuit. There's not really anything to say about the defendant in the control case, the control condition. And there's pretty standard testimony about the impact of the injury, and we don't really call into question the experts who are testifying. Now, the experimental condition, and this is the sort of kitchen sink approach, that is, we changed many things simultaneously. We decided, based on the national poll, to use neck injury, right? Not whiplash, neck injury. Forget soft tissue, forget connective tissue injury, just plain old neck injury. But the defendant's terminology was not changed, right? So it's whiplash or neck injury, whiplash or neck injury. So half of the case is describing it as a neck injury. We also attempt in a number of ways to try to distinguish our plaintiff from the prototype. We explain the motivations for the lawsuit. We talk about how he tried to make ends meet, lawsuit was the last result. Some of these things come out in the opening statement and some in his own testimony. We also attempt to tar and feather the defendant. I think some of the comments that were made in the first session about the importance of personal control and the sort of this important concept of personal control, and this is something that I think many attorneys would be motivated to do nonetheless, was to try to see how, initially here she is and she's the victim herself of those troublesome children in the back seat. And so we provide alternative things that she could have done with the troublesome children in the car, like pull off the road and get her car under control. So we also expanded the impact, added some analogies to whiplash that have been suggested by various plaintiffs' attorneys, including the egg carton analogy. That is, all of us have had this experience of getting an unblemished egg carton, opening it up, and seeing one or more broken eggs inside. And the plaintiffs' attorneys seem to like this, and so we put it in there. And we also took into account Kahneman and others' idea of framing the value of an injury by talking about how much an injury is worth and so on. So we did all those kinds of things. Now, after all that, remember, I'm looking for changes in the plaintiff and how the plaintiff is now perhaps perceived in a somewhat different way. There was no, I'm here to tell you that was a failure. There wasn't really any change on plaintiff credibility judgments or the seriousness of his injury. Instead, the tar and feathering approach seemed to work for the defendant. So he got a relative advantage, but nevertheless, I felt puzzled. This overhead shows what happened in the control conditions, which on here is green bars, and what happened in the experimental conditions. The defendant, people loved this defendant. It's quite intriguing to me. When I looked at the credibility ratings right after the, we asked for credibility ratings for all of the participants in our mock trial and in our pre-testing, and what we found was the very highest rated person was the defendant, the woman. It was a surprise in a minute, but actually, I think I now understand at least part of it. In the control condition, you see actually that most people think by saying, hey, I did run into the guy, I accept and admit this liability. She, in fact, did herself a tremendous favor. That is, that gave her a major boost in credibility. If you think about communication theory, about making arguments or providing evidence that is counter to your own interest, this was really very positive. Now, the experimental condition, we got some more people down here saying she's not accepting responsibility, as that was, in fact, apparently a successful theme that we got across about what else she could have done, what other things she could have done if she were truly accepting responsibility and being a responsible, good mother, which, she was not in this case. We did also find that tarring and feathering the experts worked. If we looked at all of the witnesses together for the plaintiff's side versus the defendant's side, the experts and discussing the business of expert testimony, sort of hired gun kind of inferences that one might make, also seem to work. And so it apparently was successful at that. So, what didn't change? I mean, what did change? Tar and feathering. I mean, what didn't? So we could make people feel bad about experts or the defendant, but we couldn't make them have a different view of the plaintiff's credibility, the seriousness of the injury, and I know what will be most important to the plaintiff's attorneys, the amount of money damages. So I'll close by just raising a couple of questions, and I'd invite your comments on them. One has to do with some of the theories that have been developed to explain the suffering of victims. If you think about the role of emotion, and certainly people who talk about defensive attribution, beliefs in a just world, feeling disturbed at the presence of injury, whiplash, connective tissue, soft tissue injury, these are minor injuries. Perhaps, in fact, people do not engage in a strong emotional way with those particular injuries. Although they may and appear to engage in this idea of fraud and this notion of people trying to get something for nothing, avoid personal responsibility, not the defendant, but the plaintiff. I'd also love to hear from you about why you think we were not successful in modifying the plaintiff's position here, and what would be or might be some more effective strategies to present the plaintiff's case in a more positive way and distinguish it from the prototypical plaintiff in whiplash cases. Thank you.